Ladies and gentlemen, the jury.
Thank you for standing, folks. Please be seated.
All right, go ahead, Mr. Davidson.
Thank you, Your Honor. Dr. Ray, I think we talked earlier about the fact that part of the constellation of information that you utilize when formulating your treatment options is the history provided by a patient, correct?
Yes.
That's also going to determine or play a role in your determination of what tests you're going to order, won't it?
Within some limits, yes.
One of the things that's typically inquired into when taking a social history is the patient's history of drug usage, correct?
Yes.
And the patient's response to that may influence whether or not you order tests to determine whether they have drugs in their system.
In the case of these, likely not, because we have sort of standard trauma protocols that include that sort of testing, which we would basically apply to any patient that falls in that category, regardless of what our findings on history were.
Was Mr. Peering's urine or any other biological samples tested for marijuana or other drugs?
I don't know. I don't have documentation of that in the note that I created.
Okay. When you got Mr. Peering's social history, what information did he provide to you regarding his use of drugs?
And again, I will look at my note.
Objection to relevance, Judge. Are we talking about a specific time?
Is your objection more of a foundation as to what Dr. Ray inquires about?
Well, my objection is based on a prior hearing we had, but we could approach briefly.
Sure, briefly. Objection's overruled.
Can you repeat the question, Doctor?
I'm sorry, what did you just ask me now?
Sorry. I asked if you needed me to repeat the question because we took a break. I wasn't sure.
No, I can say that I documented in social history the patient acknowledges alcohol use and use of marijuana.
When you collect a social history from a patient, do you have a standard practice in terms of the questions that you use to elicit that information?
Yes.
What is that as it relates to drugs or marijuana?
Generally, I ask, do you use alcohol and do you use any other drugs?
Do you use, as in the present tense of the word?
I would say that's probably situation specific. In general, when collecting a social history, I'm just asking about generally whether they, not necessarily whether they currently, at the time of my visit, have used alcohol or not, but whether they use alcohol, as an example. But what exactly I asked in this case, I can't say.
Your general practice, though, absent some specific circumstance that would maybe warrant deviating, is to ask them in general terms if they presently use drugs or alcohol.
Correct.
Thank you, Doctor.
May I, Judge?
Yes.
Thank you. On that last point, Dr. Ray, do you recall the question you asked Mr. Peering about his alcohol or drug use?
I don't specifically.
Okay, and your report indicates that the patient acknowledges alcohol use and use of marijuana. Would you agree that doesn't distinguish a time period?
Yes.
Okay, and so, do you typically put quotes if they make a statement regarding alcohol or drug use?
If I think it's particularly relevant, I might. I did not in this case.
Okay. So do you recall if he was talking about marijuana use that day or at some other time in the past?
I don't recall.
Defense asked you about this trauma bay area where it's separated by curtains. Did I describe that accurately?
Yes.
How big is this trauma bay area?
It's probably 30 feet wide and maybe 18 or 20 feet deep.
Okay, and defense asked you if people could talk to each other across curtains or through curtains. What was the situation like when you received these patients?
Well, we certainly had a whole lot of people in all three of the trauma bays. The patient that I didn't see, that I personally didn't care for, was being attended to by the trauma surgeon who was on call, the other emergency department physician, and a number of other emergency department staff. And then as the two other gentlemen came in, they were also surrounded by a fair number of people.
Okay. Was it loud at times?
Certainly during the course of their initial evaluation.
And I hesitate to use the word hectic because I know you guys are good at your jobs, but were there a lot of people moving in and out of that area?
Certainly.
Was the police there at some time?
Yes.
Do you recall if these patients were having any conversations together?
I don't recall.
May I have a moment, Judge?
Yes.
All right, that's all. Thank you.
I'm going to turn to members of our jury and see if they have any questions for Dr. Ray. Does not appear that we do. Can this witness be excused?
Yes, thank you, Judge.
Doctor, thank you for your testimony.
Thank you.
You're excused. Mr. Shea, your next witness.
Thank you, Judge. The state recalls Terrence Weaver.
All right. No, he doesn't need to be resworn in. I'm going to keep him under oath. Okay. Thanks, Eli. Sorry. I thought you were going to put him on there. Mr. Weaver, you remain under oath, sir.
Thank you, Your Honor.
Go ahead, Mr. Shea.
Thank you, Judge. All set?
Yes.
All right, Mr. Weaver, so if you'll recall, just bringing us back, we were talking about the 4 fired bullets that you conducted analysis on, and we went through where those came from. Do you recall that?
Yes.
May I approach you?
Yes.
Mr. Weaver, I'm providing you with what has been marked as Exhibits 321, 321A, 322, and 322A. So I'll ask you to just take a look at those items and take a look and recognize what they are.
Yes, sir, I do.
And what is each one of them, and if you'll make reference to the exhibit number?
Exhibit 321 is my item 39. Exhibit 321A is my item 1094-1.
And those are both bullets from,
Yes, at least at this point, this is the packaging that I received.
okay, and the other two?
The other two, Exhibit 322 is my item 14, and Exhibit 322A is my item 15.
And those are both bullets retrieved from Colin Brew, is that correct?
I had no reference to item 14. I didn't see that labeling, but that was the labeling on item 15.
Okay. Can you go ahead and open up those packages, please? What did you open up?
I opened up Exhibit 222A, my item 15.
And what is contained therein?
In that exhibit is, this is my laboratory packaging. It also includes the envelope from the medical examiner and one fired bullet.
All right.
John, can I just ask the court to admonish the witness not to publish evidence until it's admitted? I don't know what's going to be coming out of these bags.
Mr. Weaver, don't show any evidence until it's been admitted, sir.
And if you'll remind me, which item, which exhibit was that, Mr. Weaver?
My item 15 was Exhibit 322A.
All right, state offers 322A.
Sure. Maureen, do we have that marked as 322A? Because we had 319A and B, but 322? No, I see what you have. I see we did mark it that way. Objections overruled.
So that was with regards to 322A, and that was your item 15, is that correct?
That's correct.
And can you open up the next package, please?
This would be my item 14, Exhibit 322. And I opened one side of the envelope and removed the contents.
And can you just describe what you find inside there?
Inside Exhibit 322 is my laboratory packaging for item 14. That includes packaging from the medical examiner and also one fired bullet.
All right, State offers 322.
Same objection.
All right, 322 is admitted.
Thank you. And if you'll open up, and Terry, if you'll, I mean, Mr. Weaver, if you'll put the items back into the larger envelopes as we move through them.
Okay, I'm placing my item 14 packaging back into Exhibit 322, and the item 15 packaging back into Exhibit 322A.
If you'll open up another one,
I'm opening Exhibit 321, which is my item 39.
And what do you find inside there, Mr. Weaver?
Inside this package is a plastic bag with the item 39 on it, another laboratory plastic bag that I created containing a plastic canister, and this was what I described earlier as what I thought was from the hospital, and one fired bullet.
All right. State offers 321.
Same objection, Your Honor.
321 is admitted.
And I am putting my item 39 packaging back into the Exhibit 321 envelope.
All right, and I'll collect that if I may. Thank you. If you'll go ahead and open up that last one.
And the fourth item is a plastic bag, or I'm sorry, a paper bag, Exhibit 321A. And this has my item 1094-1 label on it. And I've opened the end of that paper bag, and inside that is another sealed paper bag, and this also has my item 1094-1 label on it.
All right, if you'd open that, please.
And I opened that interior paper bag and removed the contents.
And what do you find inside?
Inside the interior paper bag is my laboratory packaging, and it is labeled 1094-1. It contains a plastic canister, and it also contains one fired bullet.
All right. State offers 321A.
Some objections, Your Honor, relevance 403.
321A is admitted.
And if you'll return that item to its packaging, please.
And I returned all that packaging to the exterior-most paper bag.
Thank you. If I may approach, Judge?
Yes.
Mr. Weaver, can you, so with regards to the two reports that were issued on April 20th of 2016, can you describe to the jury what analysis you conducted?
On the items that we just described?
Those items, and we also, before the break, we talked about the other items that were submitted, including the firearm and fired casings.
I would have I did test fire the item SC-16 Glock pistol in the laboratory. I collected the bullets and the fired cartridge cases, and I compared those to the fired cartridge cases and the bullets, the item numbers that we've already described.
All right, and as far as the test firing goes, was the firearm functional?
Yes, I found no malfunctions with the firearm.
What was the caliber of the weapon?
It is a .40 caliber, .40 Smith & Wesson.
So you did test firing and then you made comparison, is that correct?
That's correct.
And you described that to the jury?
Your Honor, if it'll speed things up, the defense will stipulate that items 322 and 322A were fired from Stevens' pistol. Item SC-16 already admitted to evidence. The defense will further stipulate that item 321A was fired from Stevens' pistol, already admitted as exhibit SC-16. The defense will stipulate that item 321 was analyzed and it could not be, Stevens' pistol could not be ruled out or determined to be the pistol of origin. Defense will also stipulate with regard to the analysis performed on the spent casings that were recovered by the scene and analyzed by the witness, Your Honor.
Will you accept the stipulation?
Yes, Judge.
All right.
So Terry, you've now heard the parties have stipulated to your findings. If I may just have a moment, Judge.
Sure.
All right, Mr. Weaver, would you, so I think we have a stipulation to the analysis you did, the conclusions that you drew. Would you agree?
Yes, sir.
All right. With regards to at least those two April 20th reports, is that correct?
Yes,
And you issued one additional report in this matter, is that correct?
I did.
And when was that issued?
The date on this report is April 29th of 2016.
Okay, and what were you reporting when you issued that report?
If I may just read from the report. Per discussions with Case Sergeant O'Hagan and Deputy County Attorney Barker on the 20th of April 2016, the request for distance determination on items 10, 11, 19, and 35 was withdrawn.
What were items 10, 11, 19, and was it 35?
Yes, sir. These were all clothing items.
All right. Did you have an indication of the origin of those clothing items or what they were purported to be?
The indication that I had came from an addendum to the request for examination that I had.
All right, so they were all clothing items. Do you know who they belong to?
Item 10 on that addendum is described as black BLK pants dash Zyntech. Item 11, red t-shirt, Zyntech. Item 19, black BLK jacket, Zyntech. And item 35, black BLK t-shirt of Peering.
Okay, so those items, fair to say those items had been submitted to you, to your lab, for a specific type of analysis, is that correct?
Yes, sir.
And what type of analysis was requested?
The request on this addendum was to please check for stippling on all four of these items.
Okay, and was that analysis done?
No, it was not.
Why is that?
I had a discussion with the case detective O'Hagan, and we clarified what the word stippling meant. I wanted to know if that referred to gunshot residue, and he was looking for a distance determination, and he verified that that was what the request was. The reason that that was not done was because of the evidentiary value that determining distance might have, or the lack of evidentiary value.
All right, so would you have had the ability to determine distance based on what had been submitted to you?
I would have had the ability to attempt to determine distance.
And you elected not to do that, is that fair?
That's correct.
Why?
Because, again, in determining distance, I have to ask what the evidentiary value is. And with distance determination, and my understanding of the scene, which is somewhat limited, was that the individuals at the scene were mobile. And in doing distance determination, I cannot determine who might be moving towards whom might be moving away from whom. I can't tell what may be going on in someone's mind with distance determination. And again, unless I have a very specific reason to do that distance determination, there is a lack of evidentiary value there.
All right. And so you indicated that to the case agent and the prosecutor, and then the decision to withdraw the request was made. Is that right?
Yes.
If I may have a moment, Judge?
Sure.
One further question, Mr. Weaver. How many times have you done that type of testing in the past, and under what circumstances?
I've done variations of that testing. Maybe rough estimate would be about 10 to 20 times. And the circumstances are quite variable as to my reasons for doing that.
Okay. Nothing further at this time, Judge.
Mr. Davidson?
Thank you. Good afternoon, sir.
Good afternoon.
If hypothetically you had done the distance determination analysis that was originally requested, saying generically, not just with regard to this case, what would the significance of the presence of stippling on clothing be?
I'd like to clarify the word stipulating. That is more commonly a term used by medical examiners. It's associated with red marks produced by gunpowder particles, and another term that is used is tattooing, and that refers to gunpowder particles that may be embedded underneath the skin. What I specifically look for in distance determinations is a nitrite pattern. When gunpowder particles burn, they form nitrites. I also look for possible lead wipe and possible vaporous lead using a test called a sodium rhodizonate test.
And tell me, if you could, please, what the significance is of any of those three tests and the result you get a positive result.
If I get a positive result, it would at least indicate the passage of a bullet
Okay. What
through
about
a garment. I'm sorry.
I'm sorry to interrupt you, sir. Are you done?
Passage of a bullet, typically through a garment.
You're talking about the lead wipe?
No, I'm referring to all three of those, the lead wipe, the vaporous lead, and the nitrite pattern.
Well, as it relates to distance determination, though, what inferences can be made based on the results of those tests?
There may be some examiners who will use vaporous lead as a distance determination, or possibly the maximum distance at which that may be found. However, the nitrite pattern in our laboratory is the determination of distance. And that pattern, which is basically a spotted pattern that is eventually transferred to photographic paper, is then reproduced or attempted to be reproduced using same ammunition and firearm associated with a case.
Okay. So let's say you have a nitrite test that's positive. My question again is, what inferences can be drawn with regard to distance determination?
With a positive nitrite test on an evidence garment, testing would be done into cloth, preferably the same type of material that the garment is made out of. And if that pattern can be reproduced, there may be the ability to determine a range at which the firearm was fired from that garment.
Is there a particular range that would be applicable to a positive test across the board, or does it vary from case to case?
It varies from case to case. On occasion, at closer ranges, closer distances, there may be a range within about 6 inches determined. However, as you move further out, in the past, I believe I've reported out ranges up to 1 foot.
So you indicated in order to do a distance determination, you need the firearm from which the projectiles were originally fired, correct?
Yes, sir.
And you need the ammunition similar or of the same type?
Same type ammunition, yes, sir.
You had item SC16 available to you for testing, did you not?
Yes,
That's the Glock 22, correct?
that's correct.
There were, I think, 6 unspent shell casings of .40 caliber cartridges available to you as well, correct?
Yes, I had those to use at least for reference determination.
Okay. But they were available to you.
Yes, sir.
And you had various clothing, evidentiary clothing, belonging to Kyle Zintek and Nicholas Peering, correct?
Yes.
And when this evidence was initially submitted to you by the NAU Police Department, the request was for you to do a distance determination.
The original request was to check for stippling.
The significance of which being that could be telling with regard to the distance between the muzzle of the gun and the location of the individuals who were shot.
Once we clarified what stippling meant, yes, that was the inference of the request.
Okay, let me, I'm being too wordy, and it's my fault, it's late in the day. Your understanding after having this conversation with the prosecutor, Detective O'Hagan, was that they used the word stippling, but basically they wanted a distance determination. Is that fair?
That's correct.
Okay. And then you had a conversation with them and said it's not appropriate to do a distance determination in this case, correct?
I'm not sure I used the word not appropriate. I believe the conversation was more directed towards what specific evidentiary value it might have.
What level of familiarity do you have with regard to the various witness statements and accounts of what happened at the time of this incident?
I've had no access to that information.
So you don't know whether it's a well-agreed upon fact or a matter of deep contention that the person who fired the gun and the person who was shot were or were not mobile at the time the gun was fired, do you?
I have basically general information that there was some mobility there, but I did not have specific information.
The degree to which that was a contested or an uncontested fact of the case, though, is that something that you have any knowledge of?
No, sir.
Okay. So when you made the decision, I don't want to split hairs or put words in your mouth, but when you made the decision based on the perceived mobility of the players involved to not proceed with the distance determination, you did not necessarily know whether or not mobility of the people involved was established or not established.
No, sir.
If the mobility of the people involved was found to be non-existent, in other words, if the mobility of the people involved was determined to be such that they were stationary at the time the shots were fired, there would be value in doing a distance determination, correct?
I would have to have the detailed information, the very specific information, and then evaluate that information to perform that analysis.
So even if there is some measure of movement, either with the person who is shot or the person who fires the bullet, that doesn't necessarily render a distance determination impossible. It's just going to expand that range that you're going to get when you complete your analysis, isn't it?
I'm not sure what you mean by expand the range.
Well, you testified before that when you do a distance determination, the result is essentially a range of distance between the muzzle of the gun and the person who was shot.
That's correct.
Okay. My question to you, sir, is if there's some measure of movement, depending on the degree of it, is it going to make a distance determination test impossible, or is it just going to make that range a little bit broader so that your analysis is somewhat less precise?
The determination of movement or whether movement exists or does not exist is not something that the distance determination can make. And so if it is possible to make a distance determination, then I cannot say what the relative movement is between the gun and the garment that was shot.
But you can make a determination, or at least a range, as to the distance between the gun and the person who was shot at that very moment in time, even if the people are moving either apart from one another or closer to one another, can't you?
That's possible, yes, sir.
Okay, so whether they're moving and a second later they're going to be closer or further apart, you can still, with a distance determination, determine how far apart they are from each other at that critical moment when the shot is fired, can't you?
Possibly.
Now, we don't know if you could have done that in this case because you didn't proceed with the testing, correct?
That's correct.
Now, let's assume hypothetically, because I know you're, and I don't mean this in a pejorative way, I understand that your knowledge of the case is somewhat limited. Let's assume hypothetically that it's not at all a matter of dispute that the shell casings that were recovered and the bullets that were recovered were all fired from Stephen's Glock 22. Item SC16, I believe, was your evidence item. What, if anything, did your analysis add to that particular issue?
My analysis of those bullets and cartridge cases verified that, demonstrated that those bullets and cartridge cases came from that gun.
But if we already knew, hypothetically, that those bullets and cartridge cases came from that gun, fair to say your testing didn't add anything, did it?
I would never make the assumption that those bullets and cartridge cases came from that gun. My purpose in the laboratory is to examine those bullets and cartridge cases and attempt to determine if they can be identified to that gun, or if possibly there may have been a second gun involved. And that is my job in the laboratory, to clarify that evidence if it can be determined.
Well, you talked earlier about the concept of evidentiary value. Do you recall that?
Yes, sir.
Okay, so if it's not an issue of dispute in a particular investigation as to the gun from which bullets were fired, what evidentiary value is it to perform the analysis that you did do in this case?
It's not a question of dispute. It's a question of examining that evidence and determining where that evidence may have come from. In terms of doing distance determinations, that is a different perspective on what evidentiary value may mean.
Okay. Let me move on. You had clothing, I think we established, I apologize if I covered this already, for Mr. Zintek and Mr. Peering.
Yes, sir, I believe that's correct.
As we sit here today, do we know whether either of those, any of those 4 items have evidence of nitrite deposits on them?
I do not, no, sir.
During the prosecutor's examination, sir, you had an opportunity to utilize the flashlight that was affixed to the pistol. You recall that?
Yes, sir.
I'm sorry. And you described for the jury how the switch works. Do you recall that?
Yes.
Can we agree that there's essentially 2 different ways that the light can be illuminated using the switch?
Yes, I believe I demonstrated that.
And I apologize if you went over this before, but just so it's clear to the jury, there's essentially one side of it that could be used as a toggle, like a light switch on a wall, and then another portion of the switch that acts as a pressure switch, correct?
Yes, when you refer to pressure switch, it locks the switch in place.
But is there not also a means by which the light can be activated by the operator or the user holding constant pressure on some part of the switch?
I'm sorry, I may have misunderstood. Holding the, as from the perspective of the shooter, holding that left side of the switch down will turn the light on. However, if you release it, the switch will automatically turn off. Holding the right side of the switch down will click the switch into place, and the light will stay on.
So it's certainly possible to utilized that light in a fashion such that it would automatically turn off once you released pressure off your finger from it, correct?
Yes, sir.
Okay. Now, would you agree with me that it took you a fair amount of time to remove the light and to put it back on?
A fair amount of time is relative.
More than a few minutes?
No, I don't think minutes to take that light off.
How long did it take you, sir?
I wasn't timing myself, but I don't think it was 3 minutes.
Okay. Well, let me ask you this. Is it something that snaps on and snaps off in a quick release?
No, there's a bolt there that you can operate by hand. It also in it, I think it's designed to use like a coin in it. And so you have to twist that bolt to loosen it up enough to take off.
Similarly, you have to tighten that bolt to secure the light in place, correct?
Yes, sir.
So basically, you have to screw it down on that rail you were talking about.
Yes.
It's not like there's a simple lever that you just push in one direction or the other to lock it or unlock it, correct?
Unless I missed something, unless you can adjust the bolt, so you might be able to press it to take the light on and off. That's a possibility. I didn't look at it that closely.
Okay. If you were to look back at it again, would that refresh your memory?
It's something that I would have to play with, and I'd rather have it in the laboratory to be able to actually examine it.
Well, can we agree that when you unmounted and remounted the light today, you had to turn that screw as you described previously?
That's how I operated it. Whether it had been preset for a quick release, I can't answer that.
If I could have just a very brief moment, Your Honor.
Sure.
Did you perform any other analysis in this case other than what you've described so far?
When you say perform any other analysis, it's a little bit difficult because in, for example, examining the firearm, I go through a rather detailed worksheet with each of the cartridge cases, with each of the bullets. I go through rather detailed worksheets. I photograph these items, and so there is a lot more to what I did than what we have actually discussed.
And I'm not suggesting that your analysis was something that was easily undertaken, but in terms of any other specific requests from the prosecutor or the police department or reports that were generated, have we covered everything?
In terms of my reports, as opposed to my notes and the results, I think we've pretty well covered everything.
Have you ever conducted what's referred to as an ejection pattern study?
I have done that on rare occasions in the past.
An ejection pattern study is essentially done to help determine the direction and distance from which a firearm will eject a spent shell casing after it's fired, correct?
That's correct.
If you know the direction and the distance that spent shell casings tend to go, and you know the location of where the shell casings are recovered, using those two pieces of information, it can help you get a better idea of where the gun was physically located when it was fired, can't you?
Possibly.
That wasn't done in this case.
No, sir.
Was it requested in this case?
I'd have to go through the request in detail, but I don't recall that being requested.
Thank you, sir. No further questions.
Thank you, Judge. Just on that issue, Mr. Weaver, the ejection pattern testing, you indicated you've done that on rare occasions. Are there shortcomings to that type of analysis?
Yes, sir.
And can you describe those, please?
The shortcomings are the scene itself, and I'm speaking generically. If you have a scene with a hard surface, possibly a sloping surface, intervening objects, people moving around, cartridge cases can roll on hard flat surfaces. They can roll more on hard sloped surfaces. They can hit objects and bounce off of them. People at a scene, including possible emergency personnel, can move cartridge cases around. So there are so many variables there that in order to do an ejection pattern, conditions have to be pretty much ideal.
And in addition to the scene, how about, is there any issue relative to how the weapon is held?
Yes, that's another variable. Depending on how the firearm may be rotated as somebody normally shoots a firearm, and I'm talking about a lateral rotation, that can greatly affect how cartridge cases are ejected.
Okay, and so what we're talking about here is when a weapon like this one is fired, a cartridge is ejected from, why don't you describe it? You'll probably describe it better than me.
This is referred to as a semi-automatic firearm. When cartridges are fired, the slide moves rearward. I don't know if you may have noticed the slide when I was handling the firearm at the top of the gun there. There's a hook of metal that pulls the cartridges from the chamber, the location where they fire, and then there's another pin of metal that ejects the cartridge cases away from the firearm.
Okay. And so that's in the pattern that counsel asked you about would be what pattern? Is that what it's called, ejection pattern testing?
Yes. However, the pattern determination is where the cartridge cases actually land, if that can be determined. I do a general ejection determination when I test fired the gun in the laboratory, and this particular firearm was generally ejecting cartridges to the right, and it also had a strong vertical component to it. In the trap that I fire into, there were cartridge cases that were actually landing on top of the trap in front of me, which is a little unusual.
If I may have a moment, Judge?
Yes.
I apologize, Judge. I think I indicated one question. I do have another question, and this is going back to the distance determination that counsel asked you about. Mobility, I believe that the hypothetical questions that counsel was presenting were trying to control for mobility. Is mobility the only variable that causes you to have a concern about the evidentiary value of that type of testing?
The mobility is a strong aspect of that, but it is also the speed at which people can move. If a distance can be determined out to about 2 feet or possibly 3 feet, it can take a very short time for someone either moving away or moving towards someone else, or two people moving away or towards each other, to move within that range at which a distance could be determined or out of that range. With distance determination, if you get negative results, if you get negative results on that nitrite test, then you cannot draw the conclusion that somebody was beyond the distance at which those residues might be found. And the reason for that is because there may be intervening objects. The EMTs that may handle that evidence may shake that evidence off or may affect it. And the material itself, nylon jacket may retain that evidence much more differently than a cotton shirt. So there are just a large number of variables there.
Nothing further, Judge. Thank you.
All right, I'll turn to members of our jury and see if they have any questions for this witness. Looks like we do, so I'll see counsel and court reporter at the sidebar. So, Mr. Weaver, the jury does have a couple of questions for you. The first question is, do you or can you estimate a muzzle flash distance on a Glock Model 22?
Muzzle flash distance is not something that we would do in the laboratory. We would, and actually I'm not familiar with that being done in firearms and tool marks, although somebody certainly may have worked with it. But normally what we would look for are the residues that are deposited that are associated with that flash.
The next question is, can you determine the strength of the flashlight's lumens?
No, I did not measure how bright that light was. I only determined if it was operating. And it's possible that if you looked up that flashlight, there should be a rating somewhere on how bright it is.
Right. Follow up.
Nothing, Judge, thank you.
Mr. Davidson.
Thank you very much, Mr. Weaver. What is muzzle flash? For those who don't know.
Common understanding of muzzle flash is actually a light that would be produced at the muzzle from the burning of the gunpowder.
As the gun is fired.
Yes, sir.
Essentially, and I'm trying to avoid using the word fireball, but basically it's a very quick light, similar in hue to a fire that momentarily exits the muzzle of the gun as it's fired, correct?
Yes, it is very rapid, and I think typically it's going to vary depending on the firearm and how the muzzle is designed. But I think typically it has a conical pattern to it.
Is it something you typically expect to see with a semi-automatic pistol like a Glock 22?
Without any kind of a suppressor on it, yes, I would expect to see a muzzle flash.
Thank you.
Can this witness be excused?
Yes, Your Honor, thank you.
Mr. Weaver, thank you for your testimony, sir. You are excused.
Thank you, Your Honor.
All right, folks, let's go ahead and take our final mid-afternoon recess break, 10 minutes. Please remember the admonition. All right, folks, we'll see you in 10 minutes. So, Mr. Shea, I think it was Mr. Davidson, what do you want to do about those bullets? I mean, I wasn't trying to, to indicate any position one way or the other. It's just that, one of the things that, if any of you decide to become judges, you're going to get in judge school firearms with live ammunition in the jury room. So I don't know how you want to do that.
Just in the past, we've just had a rule, if we admit both of those, they must be in the jury room at the same time, so they have to notify the bailiff, we notify the clerk, and do a switch.
So do we need to,
That's what I would,
do we need to instruct the jury then as to those particular exhibits that that the gun and the live ammunition will be presented to them for inspection, but separately, so that they're not in the jury room together?
on request, and that's, I think Marie would try that way too. That's what I would propose, that's okay with the
Yeah, I mean, as long as you're not going back there at the same time, I guess it
Right.
makes too much harm.
Did I tell you guys the story? I know I haven't told you that. Yeah, but did I tell you guys the story about Judge Adams, and he was a prosecutor, and the Anthony Lee Cheney case? It was a brutal, brutal case. It was the first, he was, it's horrible. Doc Jameson was the first basically Coconino County law enforcement officer that was killed in the line of duty, and it was a brutal case. And Anthony Lee Cheney and his, I think, girlfriend, the Doc Jameson was reserve deputy, came upon them, their campsite, and so Anthony Lee Cheney literally started firing on, I can't remember, I did the death penalty appeal as a prosecutor, but he literally walked up on him and emptied this like M1 on top of him. And so it comes to trial, and if you went into Judge Adams' office, you'd see this big picture from the Arizona Republic of him holding up this M1,